A very good afternoon, one and all present. Today, we are going to understand in the second lecture of Law of Crimes about the liability part when it comes to crime. So, I would like to take you to a very important section, two very important sections of IPC, which is talking about the liability or the collective liability and individual liability of a crime. Before that, I would like to make the students aware about this very concept as to why do we need to understand that there is a liability part. When in the last lecture, when we were talking about the maxim actus non facitrium nisi mens rea, we are talking about that every person who has committed an act with a guilty mind should be responsible for getting the punishment. Now we come across a situation where a crime has been committed. Let us take an example, theft, or let us take an example of arson or mischief or murder, where more than one person are responsible or one or more than one person is involved in commission of that crime. Now it becomes difficult for us to understand who has committed. If there are 5 people for commission of a crime, it becomes difficult for us to understand who actually has committed the crime and whose role is more important. And for that sake, we will have to understand the very important principle which is given in the law of crimes, which is also called as IPC, which is now is converted to the Bharatiya Nyaya Sahita. So let us see about the present this particular slideshow, where I am going to discuss with you the important part or the important aspect of the section 34 and section 149 of IPC. Now, as such, as I was talking to you, let us understand what is a liability, what does liability means. So when I talk about liability, liability means that who has committed the crime and he or she should be punished for that particular type of crime which he has or she has committed. For the sake of understanding of this lecture and for the coming sections, in law of crimes, that is either we are talking about IPC or we are talking about BNS, there is no differentiation based on gender. Any person, whether is female or male or third gender, can commit a crime and they can arouse the liability for the sake of punishment. So if we just talk about the liability in the law of crimes, we find that it is of two types. One, which we are talking of, is the individual liability. So what is the individual liability? Suppose I am talking about Mr. A, my client has committed theft. Individually, he will be punished if caught, and if investigated properly, he will be punished for the punishment which is prescribed in IPC. Then we are talking about the collective liability, or the where we find that the commission of a crime has been by more than one person. We have to determine that how much each person has contributed for that commission of crime, and we are going to make him or her or that group to be punished for the being there as a collective liability. I would like to discuss with you one important case of 1993. In Bombay, what has happened was that some blast happened and thousands of people have died, and lakhs of property blasts have taken place, and we find that it has resulted into loss of life and loss of property. But surprisingly, even today, that investigation is still ongoing because of the fact that we could not arrest Mr. Dawood Ibrahim, who is the mastermind for the blasts in Bombay in 1993. Although now the question comes that whether Mr. Ibrahim was involved into the blast, whether he has actually executed those blasts, whether he was present at the crime scene, whether he himself has committed that type of a crime, the answers to all these questions are in negation. But still, he was the mastermind, which means that he was the person who has been the instigator to commit the crime of blasts in 1993. Hence, the principle of law of crime arises that if there are people who have committed a crime collectively, we have to deal with them, or we have to fix the liability with each one of them as if they have jointly and individually have committed that crime. So we have in the IPC, we have certain sections that is talking about the collective liability or the collective understanding of how a person can be punished. Now these are the sections which I'm talking about is speaking of a principle. They are not speaking of the crime. So collective liability has been defined. I am taking for the sake of understanding from section 34 to section 38 plus section 149 of IPC. Now, the understanding is, the concern is why I could have written it 34 to 38 and 149. But in fact, when we will discuss it further, this comparative understanding of what is the common intention and common object as far as the IPC is concerned, you will be able to correlate this aspect of why I have discussed it separately. When I am talking about section 34 to section 38 of IPC, it is just the principle. So I am not discussing about any crime per se. But when we talk about section 149 IPC, it is a crime. Now, what does it mean? It means that we have to apply these principles in every case if we find that there are more than one accused or more than one criminal involved in the commission of crime. Whereas when we are talking about section 149 IPC in any particular incidents, we don't have to prove anything. We don't have to look for the principle. Every person who is involved in that particular act will be punished as if he is the criminal. So what exactly is this as far as the law suggests? So if I will put it instead of the sections, if I have to put the marginal title of the section, I'll just take the different color. Section 34 IPC is talking about the common intention in a particular set of incident or a particular set of crime. This is the common intention. When I am talking about section 149 of IPC, it is talking about the common object. So one by one, we will understand that what exactly is the comparison between these two sections of IPC, how do they are comparable, and how far do they make the liability thing explained when it comes to the law of crimes. So let us move to the next slide, and we find that the section 34 and section 149 are talking about the principle of constructive liability, which means that constructive as such, when we talk about constructive in law, it means collective. So I am in the construction of something with my friend or with my friends or with my client or with my clients. This is what it is talking about, constructive liability, which means that an individual is responsible for the repercussions of even someone else act. But we are talking about these two things comparatively with each other. So the understanding is 34 is absolutely different, 149 is absolutely different. So when you talk about that the criminal intention is concerned, we have discussed about what is mens rea. So mens rea is the highest element of crime which is there in a person's mind. We consider that act no doubt is important, but many a times an act has been committed for a sake of someone else's guilty mind. I can give you one example in that regard. Suppose the question is whether my client A is responsible for demanding of dowry from his from his son's in-laws. If this is the question is, Mr. A has been responsible of asking dowry from the in-laws of his son. This is the question. It has been stated that Mr. A is completely against dowry, but the sister of Mr. A, whom Mr. A has a lot of affection with, she insisted A that at least a motorcycle should be asked from the in-laws of his son. Now, if this is the understanding, and subsequent to this type of pressure or this type of a request repeatedly from the sister, one fine day, Mr. A went to his in-laws, son's in-laws, and stated that, sir, if possible, in the marriage, you can give a motorcycle to my son. The groom's aunt is very much interested to show it to the relatives. If this is the thing, we find that there is a common intention of my client A and his sister to ask for a dowry. But if you just look to the other facts, he may not be otherwise interested, because in principle, he doesn't want it to be asked for. But because of the instigation, because of the abetment, he has committed it, which means that both Mr. A and his sister are having a common intention, and we have to look how far the pressure from the sister is responsible, or how far Mr. A himself is responsible to ask for the dowry. Now, when we talk about this is mens rea. So when you talk about the nature of intention, it becomes very, very important, and it has become compulsory for us to differentiate whether there is a common intention of Mr. A and his brother and his sister, or there is a common object. Like both of them are interested to get the dowry, but actually the sister is more vocal about it and more pressurizing about it. This is the difference between section 34 and section 149. So we will see that how far the principles make the things clear for finding out the situation when we are talking about collective or constructive liability when it comes to crime. So we have already discussed it, that intention has not been defined. The IPC has been using this term many times, like whoever intentionally or whosoever has got a dishonest intention to commit a crime. So we find that intention has been used many times in IPC, now in BNS, but actually it does not defines it. So what exactly would be intention? And as I have discussed you earlier, how to find out the intention of a person, or a person who's guilty, or a person who is into question, how to find out the intention of a person is to look at his acts. So one part is when I'm trying to tell you that the intention, when we are talking about the principle of liability, actus non facit reum, nisi mens sit rea, which means that not only physical actions but also the mental elements are important for us to determine the liability of a person when it comes to crime. But when we talk about the intention can be reflected by the acts of a person. So we say that the intention which is made among several people to do something wrong, and the act done in that manner which it is formulated, comes under the sanction of section 34. I would like to again repeat it. Section 34 of IPC is not a crime. It is just a principle. Many a times when the students, when the students become judges, they find that 34 is a sort of crime. No, 34 is a principle of joint liability. When you find as a judge that there are more than one person is found to be involved in a crime, you can impose section 34. What the importance of, or what happens next, or what is the importance of section 34, application of section 34 of IPC in such matters? It makes the action grave. So if I'll tell you that one person has committed a crime in the rage or anger or intention, in emotion, you as a judge will feel that maybe we have to be a little bit liberal with him. But when I'll tell you that he has committed 10 meetings with his 3 friends, and then he has acted in such a manner that this crime has been committed, definitely you will find that the action is to be punished with severity. So when we talk about section 34, section 34 is talking about of IPC with a situation, and we call it as a joint liability. And in section 34 of IPC is designated to deal with the situation where it will be very difficult for us to differentiate between the acts of more than one person involved in a criminal act. So we see that I would like to discuss with you here before going to the ingredients of section 34 IPC. Please note it over here that this section is of Indian Penal Code. There is a case of the Barender Kumar Ghosh, Barender Kumar Ghosh versus King Emperor versus King Emperor. This case has been decided by the Privy Council, and it is a very old case. This is a case when we were not independent but a colony of UK. What has happened in this case was that a group of people who declare themselves as interested to get the money for various reasons. It is not known because, as you can understand, that it was tried and it was an English time. We can't rely on what they stated, but the facts of the case is like this. More than 5 people were involved in a crime where they were interested to loot the general post office, where you must be knowing that even the as of today also the GPO is also responsible for deposition of money. So these 5-6 people were interested to loot, involve into a robbery in that GPO. And what they took is like they decided that they will take the help of the people who were working there, and they created the blue plan or the sketch of the bank. I'm sorry, GPO. And one of the person has collected some firearms, and one person was made to stand outside the gate of GPO. He was being instructed by the members of his team that if he saw that there is police officers coming or there is a threat, he should whistle and make them alarm. Now, the execution day came. This person was standing outside the door, and all these people went inside, and then they asked the postmaster, general postmaster, to give them the cash. Unfortunately, the general postmaster actually he resisted, and this team, the team of accused person, they have to use the firearm. The general postmaster was dead on the spot, and all of these they started running. The police was nearby, and the police caught hold of this person who was standing outside the gate. Now the question was, he was being tried, and later on, after the investigation was completed, the entire members of this gang were all arrested. The loot money was also found by the police, and they were tried together. This person said that, sir, they were tried together for murder of the general postmaster. So this person who was standing outside, he stated that he made an appeal to the Privy Council, stating that he was all punished by the lower courts, but he made an appeal stating that he was not involved at all in any act, because he was simply standing. His role was only to whistle or to make alarm. He was not holding any firearm. He was not knowing that the firearm would be used. As he was standing outside, he was not knowing this fact that his team were carrying the firearms. Privy Council stated that we have to look to the principle of section 34, where it is talking about the principle of common intention. How far this person who is standing out has committed less offense as compared to those person who were carrying the arms. Once they started, this person was aware of this fact that his team was carrying firearms. The firearms were not for a show, or they were not artificial. They were not to just to showcase that what we can do. The firearms were taken in order that if there is a threat, if there is a struggle, we will use it. So Privy Council stated that if we apply the principle of common intention, when the entire planning was taking place, you were present, you know the fact that although your work seems to be non-important, you were not seen on the crime scene, but still you were aware of the intentions of your team members. You were aware of the fact that if found any struggle or any type of obstruction inside the GPO, the firearms will be used, and hence they made him guilty for murder under section by application of section 34. So when we look back to the ingredients of section 34, we find that there is a criminal act which is done by several persons, not just by one person. It can be one who is seen on the crime scene, or who is behind the veil. Common intention. So common intention means that this is very important, that we need to prove that if there are more than one person involved in the commission of a crime, everyone has got the consensus of mind or meeting of minds, which means that every person involved in that group have understood a particular concept in a particular manner only, which means the group has decided to purchase firearms not for show but for using it. Participation in the criminal act. So the participation in the criminal act means it should be seen that all the person are involved in the commission of a particular crime. So we see that these are the cases where we are talking about Barinder Kumar Ghosh and King Emperor, where he has been suspected and punished for the act of another. So here it is very clear that when we are talking about act of another, the appellant was not actually the person who has fired the gunshot, but he was also punished for murder. Second case is Mahbub Shah versus Emperor. In this case, the court has discussed. In fact, these are very old cases, but still you will find that the appellant Mahbub Shah. It's an old case of colonial time. He was who was 19 years old and was convicted of murder of Allah Dad by the session court, when the 34 is also involved into it. The understanding is that in this particular case of Mahbub Shah, it was very difficult for the prosecution to prove that how Mr. Mahbub Shah was actually involved when in the act where he was not aware of the crime that is about to be committed, and he has run away in that case, and hence the Privy Council has found that this person may not be the one who is guilty of section 34. We have another cases like Amrik Singh case and Pandurang versus State of Hyderabad, where there are some exceptions or some sort of extensions to the rule of section 34 IPC has been created by the court, which says that there may be a possibility that common intention may not always involve meetings and a continuous meeting, but there is a possibility that a common understanding of the cause is sufficient. And in the case of Pandurang versus State of Hyderabad, Supreme Court stated that the prior consent is something which is always important in prior to the incident, but sometimes what happens is that if the like-minded people are involved in a set of crime, there is a possibility this understanding may develop at the spot, and we can't rule out section 34 IPC for that sake. Now we will understand what is section 149 of IPC when we are talking about the common object. Now, the common object is something which is in fact dependent on section 101, 141 of IPC. Now, this section 141 of IPC is, I apologize, I'll just correct it. This section 141 of IPC is talking about a concept which is called as unlawful assembly. Now, what do you mean by a unlawful assembly? Let us understand that. The law suggested, which is as it is kept in BNS as well, it says that the unlawful assembly is that assembly which is formed by 5 or more than 5% at a given point of time, and they are doing something which is wrong act with a common objective, that the liability, the action which they are committing at a given point of time distributes the criminal liability on each one of them. So, what do we understand by criminal unlawful assembly is, every person, as you are aware, as a student of law, that under Article 19 of the Constitution of India, we all are permitted to have associations, or we are permitted, we are free to have our union, we are free to have our societies, or we are free to have our own meetings, or we can have a place where we all are meeting together. But the objective of this group or the crowd or the group of members or assembly should always be legal. When the objective of the group of or the assembly of more than 5% becomes illegal. Now, what does it mean that it becomes illegal? Which means that the 7 people have been collectively standing on one part of the road, and they are planning that they will how they will pull over the shutter of the shop which is nearby as soon as the owner leaves, and they will pull over the shutter of the shop, and they will involve into loot, and they will rob all the things, and they will be involving into theft. Now, this assembly is an unlawful assembly. What happens is that many a times people join to an assembly with a good objective, but it so happens that over a given period of time, or after a certain incidents happen, the assembly get converted into unlawful assembly, and where the unlawful assembly members may not have consensus of mind because there is no meeting. It is stated that there is a new policy of the government has come, or the new policy of the of in a university. Suppose a new policy has come up by the university that there will be a fee hike, and the students are agitated because of it. They all assembled. Now, one person has assembled to this assembly in order that he can raise his voice, whereas the other person is interested to throw a stone on the building. The third person is interested to throw a chappal on the face of someone. The fourth person is interested just to, bunk his class. The fifth person has joined just because he wanted to change the environment that he's having in the class. Now, these 5, 6 people, they have their different objective, but collectively, they are presenting against the administration, stating that you can't raise the fee. So, where we are talking about that this is an assembly, but if it goes beyond the objectives of for what it has been created, it can be declared as an unlawful assembly. And if any wrong has been committed, every one of them will be prosecuted for the act which they have done, plus the collective wrong or the group liability or the group activity which they have done. So we find that Section 149 of IPC imposes group liability on each and every member of assembly, and this is the definition of the Section 149, which says that first of all, there should be an assembly of more than 5%. This assembly should be unlawful. This unlawful assembly must have the actions committed by each members in such a way that everything is a wrong act along with what the common object they have. It's not intention. Intention is the consensus of mind, whereas the object that we are talking about is something that, okay, I'm not happy, someone else is not happy, third person is not happy with a high in the fee. So there are 7, 8 people in a group, they have all joined in stating that, you take this, roll back this fee hike. But you never know which person is interested to do what. So this is the definition which we see under Section 149 of the IPC. So we see that what are the ingredients of the Section 149. We find that the first and foremost aspect of Section 149 is the presence of Section 141 of IPC, which means that there has to be a unlawful assembly. The unlawful assembly, usually you will find that either it is created without the permission of the authorities, or if it is created with the permission of the authorities, it loses its objective and creates something else which was never the objective of the assembly. The objective is to demonstrate criminal power, to resist the law enforcement or legal proceedings, to commit criminal offense or something which is wrongdoing. It can also force others to do what they are not actually legally bound to do, and taking the possession of property for the use of with the use of criminal force, and exempting any person from using incorporeal law by using or demonstration of criminal force. So what do we get over here? The ingredients of section 149 IPC, let me be very clear, this is again is of the IPC, because BNS has changed the sequences of the sections, and we are not referring to we are referring to only the sections of IPC. So the ingredients would involve, first of all, that there has to be an unlawful assembly, right? And then after that, we will find that there is a role which is played by the use of criminal force. So what is this criminal force? It has been actually, we see that the criminal force has been defined under section 350 of IPC, section 350 IPC. If you wanted to understand what is a force, the force has been defined under section 349 of IPC. This is defining, section 349 of IPC is defining about the force, and section 350 is defining about criminal force. So when assembly which is having more than 5 people at given point of time is using criminal force for demonstration, for resisting law enforcement, for committing a crime, has committed a crime of 149, which means the first ingredient for us to prove in any case where common object has been added is whether there was a criminal, where there was a use of criminal force by the unlawful assembly. This we need to prove beyond doubt. So we find that the ingredients of section 149, and please note that this is talking about the 149 of IPC, we are talking about prosecution of common object. So common object means that something which the assembly has been, why people have collectively standing there, talking there, there is something which is called as common object. The members knew it to be likely. So likely means where one person has got a knowledge that we are going to protest for the fee hike, there is a possibility that administration will not like it, because as students we are expected to be in the class, but now since it is our concern, we are going bunking our classes, maybe that something bad can happen, and the number of persons should be more than 5. Similarly, we find that the important cases which are related to section 149 are Yunus versus State of Madhya Pradesh, where you will find that the presence of the accused person in the unlawful assembly was sufficient for the conviction to be held, which means that when we are talking about whether he is charged with that type of a crime or not, yes, he was actually a participant of the unlawful assembly, and hence we find that the court has held that the person is responsible also for the commission of crime under section 149 IPC. Now let us look between the difference of the common intention and common object given under the law of crime or the main book, which is Indian Penal Code or Bharatiya Nyaya Sahita. When we talk about section 34 and section 149 of IPC, they impose vicarious liability. Now what is vicarious liability? Which means that one person is responsible not only for the actions of himself but the action of someone else. So the vicarious liability on each individual for the acts which they might have committed collectively. The charges of section 149 is substituted by section 34 when the accused are more than if the accused are more than 5, 149. If it is less than 5, 32. The main differences of these two sections are as follows. So you can see that we find that the section 34 is not a crime, but 149 is. Section 34 is talking about common intention, which is not defined in the IPC, whereas the common object is talking about the 5 ingredients which are defined under section 149 IPC. When we talk about common intention, we require that there has to be pre-consensus of mind or meeting of minds is necessary, whereas it is not necessary in 149. For invoking section 34, it is sufficient that there is more than one person involved in a crime. But for 149, we require minimum 5 people. The crucial factor for section 34 IPC is participation, while where we do not need actually the active participation, even negative participation. Like my client has given the blue plan or the master plan of the bank to the robbers. He giving them the sketch or the orientation of where who will be found itself is sufficient that there is no active participation in that act, but still he is involved in the crime. Whereas in 149 we require that there should be an unlawful assembly, and during the unlawful assembly the person should be present there committing that type of a crime. So we see that the last but not the least, section 34 requires a common intention, section 141 requires more of common object, and section 34 IPC requires active involvement, whereas mere membership in a team or in an unlawful assembly is sufficient for us to say that they have a common objective for the same. So I will that's all that I have for today to discuss about the distinction between what is mens rea of the collective liability involved in the law of crimes, what is the distinction between the section 34 IPC common intention, and what is the difference of common intention with the common object as defined under section 149 of IPC. Thank you so very much.